I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today we are jumping into number 81 on our compilation list. We will be in 4 different judges' courtrooms on today. As always, there will be no commentary in this compilation video. There will be chapters added just in case you want to jump around when it comes to these proceedings. Also, it is much appreciated, as always, for your comments, likes, shares, and all of you new subscribers and all of you guys that's been hanging out with us for a while. I just want to say thank you. Now, let me give you a rundown on the 4 different judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge David Goggins out of the state of Michigan. Second, we will be in the courtroom of Judge David Wolfe out of the state of Tennessee. Third, we will be in the courtroom of Judge Phyllis Webster out of the state of Kansas. And last but not least, we will be in the courtroom of Judge Marlena Taylor out of the state of Michigan. Guys, these compilations have been going well because of your participation, because of you guys asking for more compilations and watching and sharing. So thank you once again. And now, guys, let's go ahead and jump into number 81.
Order, Mr. Jamal, let's just do your second one, your Citibank versus John Hayes.
Yes, and good morning, Joseph Jamal here on behalf of the plaintiff.
This is file 2425, and I've got another gentleman here, John Michael, who apparently has filed paperwork.
Yes.
Mr. John Michael, you've got semicolon Hayes, respondent. First of all, are you an attorney?
I am not.
Okay. So do you have you're alleging in, I guess, all these documents that you're somehow a representative for John Hayes. Is that right?
That is correct, sir.
So how are you, or it says beneficiary. Do you have some paperwork giving you some authority to act for John Hayes today?
The UCC one that was filed.
But no, is there an order, court order? I understand the rules and the statutes and the laws, but do you have anything that says, listen, you've got authority?
I have nothing other than the process of the United States Corporation
I
that
see.
committed started the trust in my name.
Who started the trust in your name?
The Corporation of the United States of America after its bankruptcy.
Oh, you went through a bankruptcy?
No, the United States of America, the corporation did.
Oh, I got you.
19,
So but you have
1933.
nothing that says you can represent John Hayes then.
I'm not acting as surety for John
Okay.
Hayes, that is for sure.
All right. So we've got a motion to dismiss. I don't have an attorney that's filed a motion to dismiss. I guess, Mr. Jamal, let's hear that first, I guess.
Your Honor, I guess my understanding, you said motion to dismiss. Is that for plaintiff's motion for summary
Yeah.
judgment you're referencing?
Well, you've got your summary disposition motion that's out, but he's got also, it looks like his motion to dismiss, defendant's motion to dismiss. That's one I think is probably easier to deal with first.
Okay.
I don't know what that, I don't even know what it, quite frankly, it is, but you did respond to it, it looks like. Plaintiff's response to defense motion to dismiss. Anything you want to tell me on that one, I guess?
Nothing further, but for the fact that, based on my understanding of the court rules, everything was filed as required by the law. No actual documentation is required with the notice pleading state, of which Michigan is. Notice was provided since we have provided detailed account documentation supporting our claim. So I think his motion to dismiss related to failure to state a claim and lack of subject matter jurisdiction should both be denied.
Okay.
I object to
And
those.
Mr. However you want to refer to yourself, John Michael.
John Michael, yes, sir.
Okay. What did you want to tell
I-
me about your motion?
Well, I asked all of the parties involved for validations and I sent a statement of facts. and none of which were responded to. So that would be acquiescence to the truth of my statements, which should stand in truth and commerce. I asked for a contract and demonstration where there was adequate consideration giving, and did not receive any of that. It's my understanding that the consumer credit transaction or the application was taken by the Citibank and Best Buy to securitize the collateral to the Department of Treasury for their funds. They were paid, and now they're asking for me to pay in addition to that. I did not realize any of this was true until recently. And now if I am continuing to be required to make payment in any form of negotiable instruments, they are, in my opinion, are being unjustly enriched. They have never given me a contract with a signature. They've given me valid verification by bills and statements, but never anything that would demonstrate that they ever had anything at risk or that they lost anything. Therefore, without a contract, there is no standing, there's no claim to bring remedy to.
You find there's been significant number of documents that have been filed, one being the motion to dismiss this matter. It's signed John Michael, Hayes beneficiary. I've got no indication that John Hayes, who's pleading this is filed against, is in fact here. I've got no attorney representing John Hayes. I've got some allegations that John
Sir,
Michael,
I do not
hold on, sir, it's my turn. Sir, it's my turn. John Michael is somehow representing John Hayes. That's one problematic point with the motions that were filed. It's got a notice of special appearance, but I can't have a special appearance without some authority from John Michael. I did get a chance to review nonetheless all the documentations with regard to the motion to dismiss. I reviewed plaintiff's response to that defense motion to dismiss. I do find there are a significant amount of documents that have been attached regarding this account that alleged to have not been paid. It's a credit card account of some sort. All of the addresses match up to the same John Hayes at the same address, 5141 Flagler Street, Flint, Michigan, 48532. Statements were going to that address. I see the card or the account was used on that occasion. So throughout the documents that have been supplied, I also find that there were some payments made on that account as well. Therefore, based upon all of the evidence at this point, based on this motion to dismiss, that motion is denied. And now we're on plaintiff's motion for summary disposition based on MCR 2.116. Is it a C9, C10? I guess I gotta look. C9, C10 motion. Mr. Jamal, this is your motion at this point. What, on this motion, did you receive a response to the motion for summary disposition?
I did receive a reply from the defendant. That was somewhat recently. I'm not sure if the court has that in the file.
Okay, I got it.
It's titled the reply. Let's have it opened here.
You should have it since it was filed at the courthouse.
What's it titled?
It's titled Respondent's Reply to Plaintiff's Response to Defendant's Motion to
Oh,
Dismiss.
I got that one.
Okay, that's the only one I see.
Okay. Mr. John Michael, is that the only response to the motion for summary disposition?
You asking me?
Yes.
Yes.
Okay. All right. I've got that.
That was the last response because that was I have not received anything more from them.
Okay. All right. So I've got that in my hand as well. Mr. Jamal, you can proceed with your motion.
Yeah, so the motion is primarily based on 2.116C10. Included with our motion for summary, we've provided detailed account statements that breaks out the usage of the account from a zero balance to the balance we're seeking in our complaint. we show not only usage, but also payment made towards the account. Those statements were sent to the address we currently, I believe, service was made to defendant at. Given those facts, we are seeking a motion for summary be granted in the amount as requested. And I would just indicate too, defendant has referenced seeking a wedding signature, additional contract terms, etc. However, usage of an account constitutes agreement for liability on that account. These statements specifically indicate that this account was sent and used without objection by defendant, and therefore liability should exist.
Okay. And the amount, it looks like, just on the, I don't want the court cost, but it looks like the damages for the card, the account itself is 2,349.65. Is that the right amount?
That is correct, yes.
Yeah. All right.
And that should be supported by the last statement we have included in our packet. Also has a balance of $2,349.65.
So let's see that here. Oh, way in the back here.
The payment due date on that statement is February 17, 2025.
Oh, thank you, Jamal. I was just looking for the last, here it is. Yeah, I'm sorry, February 17th, 2025. That's the last one I'm seeing. Yeah. Okay, Mr. John Michael, any response?
Well, actually, kind of my paperwork should stand on its own. There was billing statements are self-generated and lack foundation and are inadmissible as live testimony and of a custodian with a personal no one of personal knowledge under MRE 8036. Prior payments do not establish a contract liability. My my realization of the fact that the Citibank, Best Buy, and or the law firm have provided any adequate compensation to complete the contract, and nor did they express the fact that they were changing my standing from the creditor because it was my credit worthiness that created the substance for the loan. They were paid. That was basically conversion from me from the creditor to the debtor. Under trust law, it converts my standing from the beneficiary to the trustee. And I still I affirm that there is no standing that they have to file a claim against the living man. And if you're refusing to.
Mr. Michael, from what I hear, though, you're acknowledging that this is your account.
I am not acknowledging that it is my account.
Well, you just said that they used your credit standing to form the basis of the contract originally.
Yes, that is true.
So how are you not?
Therefore, if it was my financing credibility that funded this loan, how do I owe them any money?
Sure, I quite understand, Mr. Jamal.
The only response I would have, Your Honor, is he does reference admissibility. I think Michigan law is pretty clear that when it comes to a motion for summary, documentation is admissible to the extent that it would be admissible at a trial with proper foundation being laid. Foundation does not need to be laid at the motion for summary stage. There is no need for testimony or additional authentication. So the statements are properly before the court at a motion stage.
Okay. Okay, I'm just going to take a brief recess off the matter. I'm going to review the statements that have been supplied. No, nope, that's it. We're done. Nope, I'm going to make a decision. Hold on. I'll be right back on. Sir, you told me that already. I'm going to take a brief recess. I'm going to review all the pleadings in its entirety, and I'll come right back on. Okay, we can come back on the record with Citibank versus John Hayes. I've had a chance to review all the pleadings and documents that have been provided by both sides. This matter. This is a motion brought in part by MCR 2.116C10. This motion may be granted where there is no genuine issue of material fact and which would entitle the movement to a judgment as a matter of law. In determining the factual support for this claim, I have reviewed all of the pleadings, affidavits, any depositions, admissions, and other documentary evidence that's been provided today. It should be noted that the non-movement party, that being John Hayes in this matter, does not rest merely on allegations or denial of the pleadings, but also must demonstrate by documentary evidence that there is a genuine issue for trial. I do find, after significantly going through all of the documents that have been provided to me today, the consistency of the statements that went out, starting with a new account through Citibank on this account, and this account was, let's see, where is it? Card ending in 8271, John Hayes. You find that this card was used over a significant period of time. There were also payments made over a period of time. The address was sent, all of these documents were sent to, these statements were sent to John Hayes at 51. Do find it's consistent with what's been complained of the amount owing. The final statement that has been complained of today, February 17th, 2025, shows a balance owing of $2,349.65. Find based upon all the documents, all the pleadings, there's no genuine issue material fact. Grant motion for summary disposition to Citibank for damages $2,349.65 plus court costs that are being requested. Mr. Jamal, I thought I saw somewhere in here.
There was a proposed judgment submitted with the motion.
Okay. So I gotta find it.
Everything's still in order. It's typically page 7 or 8.
If it's still in order, does that mean I may have torn it apart? Is that what you tell me?
Potentially.
I'll find it here. It's probably the last page. I think I saw it somewhere in here. And military affidavit. I got everything here.
It's typically right after the military F.
Yeah. See, for some reason, we get all these statements that are attached too. As usual, I can find it right off the bat. And you know, this is one's that I can.
If needed, I can email.
Do you have the figures in front of the court costs?
I do.
What do you have?
Filing fee of $75.
Okay.
Motion fee of $20.
Okay.
Service fee of $58.68.
68.
Total is $153.68. Add that to the damages amount referenced, and total balance is $2,503.33.
Okay. Oh, here, and when you know, I found it right at the end. There it is. I do have the proposed judgment showing the amount I asked for damages originally, the total on February 17, 2,349.65, plus the court cost is just recited for a total of $2,503.33. Judgment for plaintiff in that amount based on summary disposition. Answer 2.11610. I'll sign that proposed judgment and send both of you a copy. Okay.
Thank you all.
All right. Good luck to both of you.
I object, Your Honor.
Okay,
I'd like to make a comment that you're making a judgment based on no contract. All the 6 requirements of a contract were not met. I came
Okay.
to the realization that there was no consideration and no risk and not full disclosure. And you're
Okay.
still going to judge against that without a contract?
I'm not taking questions, sir. You can put your statement on. Is there anything else?
I let my paperwork stand again, and I will
Okay,
have to file for an appeal under
sure.
Article 10 of the Constitution. This controversy is greater than $25. I will be filing in the Court of Appeal.
Leave it at that, and I've signed the summary disposition judgment I just ordered, and we're all set. Good
Thank you
luck to
all.
both of you. Okay, bye.
Fraud.
All right, good morning. We're going to go through the docket as quickly as we can so that we can start on the jail docket. 2021 CR 19158, State versus Matthew Aldridge. Are you Matthew Aldridge? Are you Matthew Aldridge?
I'm the attorney of fact for Matthew Aldridge.
You were what?
The attorney of fact.
Attorney what?
Of fact.
Attorney of fact. And what does that mean?
You know, his authorization to do legal.
Are you a licensed attorney?
No, I'm simply an attorney of fact.
Okay. And does that mean you have a power of attorney? What is your name? What is your name?
My name?
Yes, sir.
I don't have.
You don't have a name? Pardon?
Name, I'm the attorney of fact for the respondent in the area.
Well, let me explain to you. Only an attorney at law can stand in court and represent a criminal defendant. And to do so otherwise violates the criminal law statutes of the state of Tennessee and could land someone who attempts to represent themselves as an attorney at law in serious trouble. I understand what you're saying. I understand you're saying an attorney in fact. And what I want you to understand is that if you have a power of attorney, then you need to demonstrate that power of attorney. Do you have a legal document called a power of attorney?
No, I do not at this time.
Okay. Then you don't have any authority to act on behalf of Matthew Aldridge in this court. You have no legal authority, nor do you have any authority through a legal document to represent or to act on behalf of Matthew Aldridge.
Why don't we court just let me file this document?
Show it to the bailiff and he'll show it to me.
Have a copy of it.
Oh, apparently there's a copy here.
Yeah.
All right, this is in the state of Tennessee of Cheatham County and Chancery Court, which is filed in the wrong county because in the wrong court, because this is circuit court. You just be quiet.
You go to the courthouse, it comes up.
You need to listen to me instead of talking, okay? This is a challenge to the standing. The Supreme Court of the United States has stated that no corporation has standing anything to man. And then there's a quotation for Rundle versus Delaware Raritan Canal Company. And then it said, as well as it being a maximum of law, citing certain Latin phrases, dissimilar things ought not to be joined by a definition of Black's Law Dictionary. So the respondent in error requires that the state of Tennessee Incorporated and Cheatham County Chancery Court prove their standing to proceed against a man in any court of law. You have 15 calendar days to prove your standing or forever yield to estoppel, waiver, and fraud, and cease and desist this proceeding immediately. More time is available if requested. And then this was signed by Matthew O'Neill Aldridge. Is that your signature?
That's the respondent in error signature.
All right. Well, I find that Matthew Neal Aldridge has failed to appear in personally in this court for the plea day on his case, which was set for trial tomorrow. And as a result, you have no standing, sir, under what I know what you're trying to do is to try to use the sovereign citizen approach to this situation. And I'm simply telling you that you do not have the right to represent Matthew Neal Aldridge. If you are in fact Matthew Neal Aldridge, then you need to say so and stop this nonsense, because that what you're attempting to do has no legal effect. You cannot challenge the criminal law or the jurisdiction of this court by simply filing some legal mumbo jumbo having to do with civil litigation. That has civil litigation in it. It is not a criminal case that you have cited. So it has no effect on this court regarding the criminal statutes of this court. This court is empowered under the Constitution of the United States of America and the Constitution of the state of Tennessee, and by the duly elected citizens of Cheatham County to empower and enforce the laws of the state of Tennessee. And that is what I'm going to do regarding Matthew Lynn Aldridge. Mr. Aldridge is set for today to appear in court personally on what we call our last plea day before his trial date tomorrow.
Is that an article 3 trial?
To what?
Will that be an article 3 trial? A trial by jury with jury?
It would be a trial by jury, certainly it would be. But I don't know who you are. And I don't think you have any authority if you are not Matthew Lynn Aldridge to appear before this court. And you're wasting valuable time to all of these other citizens who are here today. So when I'm talking, you stop talking. No, you will when I'm finished talking. You are wasting the court's time by doing this. And I'm just simply instructing you that if you are in fact Matthew Lynn Aldridge, then this is your last day to settle your case. The trial date is set for tomorrow, and unfortunately, it will not go forward because of the fact that I have a conflict and I have to be in Stewart County on a civil matter. So we're going to assign a new trial date for Matthew Lynn Aldridge. Now, is there a problem with the jury warrants? If you put a notice up there for tonight, if we don't need you tomorrow, but we need you on February the 6th. Is that possible? General, we're going to need to set a trial date in July.
July 15th.
I'm sorry.
July 15th.
July 15th. All right. To Matthew Aldridge and the individual standing before me, whose name must not be uttered, then we will set a July 15th trial date for Mr. Aldridge. Whatever this document is that you have filed is in fact invalid because it does not cite any valid criminal statute, and therefore I'm denying whatever that might be in the way of a motion. The trial date will be July 15th. The last day for Mr. Aldridge to enter a plea or go to trial will be July the 8th. July the 8th. Now, we're going to give you a card. If you are in fact Matthew Aldridge and you're just playing games with the court regarding this nonsense that you filed, then you may get this card and you may go on about your business. If you are not Matthew Aldridge, then I would suggest to you, you relay to Mr. Aldridge that he must appear on July the 8th, or a bond revocation will take place, and his case will be will take place with him in jail, incarcerated on the 15th. That's the judgment of the court. You need to take your piece of paper and go on about your business. 2021 CR 19158 State versus Matthew Aldridge. All right. I've been handed a document that states, I, the attorney of fact, there is a ruling $25. I'm asking what form of exchange is acceptable. Also, is the trial going to be about trial by jury on the 15th of July? Only a bar member is able to respond by mail. Bill, Tennessee, United States of America, zip.
Well, my address, the address.
Pardon?
Rather have the address private, with you, of course.
Up so I can make sure I'm here. You're going to have to speak up. We've run through this before. Are you, in fact, Matthew Aldridge, acting as your own attorney?
I'm, in fact, I'm the attorney, in fact, for Matthew Aldridge.
You're the attorney of fact for Matthew Aldridge.
Yes.
Right. Now, you understand Matthew Aldridge is required to be here today because his trial is next week. And if you are Matthew Aldridge, then this is your last day to settle your case by any sort of an agreement. Otherwise, you're going to go to trial next Monday, is it?
The 15th.
All right. You'll be going to trial, and it will be a jury trial. And
yes,
you're going to represent yourself, correct?
Correct. Yes, correct.
All right.
Correct.
And we will show that you are to be here Monday. Raise your right hand. Let's place you under oath. I just want to ask you a few questions on the record. Raise your right hand. Let's place you under oath.
Yeah, affirm.
All right. How old are you?
I'll be 40 this August.
40. All right. And how far did you go in school?
I graduated.
All right. From high school?
Yes.
All right.
High school.
Have you familiarized yourself with the rules of criminal procedure?
Yes, I have been.
All right.
Yes,
so you understand what the rules are regarding a trial. Do you also understand what the rules of evidence are regarding a trial?
Correct.
And you understand that you're going to be held to the same standard, acting as your own lawyer. You have every right to represent yourself, and I'm not saying you don't. I'm just simply saying you will be held to the same standards that any other defendant will be represented by an attorney. Do you understand that? You have an absolute right under our Constitution to have an attorney to represent you. And if you could not afford one, I could appoint one for you. But you have elected, if I understand correctly, to represent yourself and waive your right to an attorney. Is that correct?
Correct.
All right. Then we will see you. I'm going to ask that you sign this written waiver. Sign right there where the X is. Pardon me. All right. I got it. All right, you have signed this without prejudice. Is that your name?
Without prejudice?
Yeah, is without prejudice your name?
3-301. Would you like?
Now, understand, we're not going to mess around when we come back next week for this trial.
I'm
not
aware
gonna
of
put
that.
up with any kind of foolishness where you don't identify yourself. Matthew Aldridge is the defendant. I know you are Matthew Aldridge. You're going to go to trial next week, and you're going to have to be in front of a jury of 12 citizens. We're going to pick a jury. We're going to try this case, and if you are found guilty, then you'll go on to appeals court, and then you'll have a right to an appeal.
Yeah.
But if you come in here and say that you are the attorney of fact, or that you are without prejudice, or whatever the situation is, you understand that I'm not going to put up with that kind of foolishness in front of a jury. You're going to have to represent yourself, but you're going to have to come in here and adhere to the rules. Do you understand that?
Correct.
And that is the ruling of the court. I'm going to show that he has that he has signed this without prejudice, but I know him to be Matthew Aldridge, and therefore I'm going to hold him responsible for a waiver of his right to counsel. We will see you on the 15th day of July, 9 o'clock.
We are on the record in 2024 TR 617. Sir, you may need to scoot over a little bit to be picked up by that microphone. I'm not sure, but sometimes you have to be in the middle with it. Mary Ann Shirley appears for the state. Are you Abel Estrada Jr., sir?
Yes, if I may, can I make a statement?
No, not yet. Okay, sir, you are charged in count 1 with on or about the 21st day of August, 2024 in Greenwood County, state of Kansas. Then and there, contrary to the statutes of the state of Kansas, unlawfully operating a vehicle, to wit, a 2011 GMC Acadia, upon a highway which does not have the signed license plate. I think they mean that the vehicle didn't, not the highway, but your vehicle did not have the assigned license plate properly affixed to the rear of the vehicle, showing the current registered year. And this is an unclassified misdemeanor. It is punishable by up to $2,500 in fines and a possible sentence of up to 6 months, 30 days minimum, up to 6 months, although probation is usually granted. Now, sir, did I not just have you in municipal court recently on the same charge?
Yes, and I don't understand why am I seen again, because that would be double jeopardy. I'm saying for the same.
Well, sir, you haven't been tried on it. You
I have,
had a first appearance on it. And
I have,
apparently the city prosecutor must have dismissed it and refiled it over here for whatever reason, I know not. But as I recall, your plea was not guilty. Is that still your plea?
yes, but I'm here to make a separation between my name. My name is Abel Estrada with low caps. This name on the top, I don't know if you can see it. This name on the top is my straw man. I am the man, and this is the straw man. So if you're calling the straw man, I'm here to represent the straw man, but I'm Abel Estrada Jr., the man, the living man.
I'm calling the living man.
So
Right. So are you going to have an attorney? Are you going to need to apply for court-appointed attorney, or will you be waiving your right and representing yourself?
no, of course, I wanted to have an attorney, but I still haven't not made my statement, which is,
Are you going to hire an attorney or apply for court-appointed?
I cannot afford an attorney, but I need to make my statement that
Let me get a few things worked out, sir. You're going to apply for an attorney, so you'll need to fill out an application for court-appointed attorney. And the deputy down there can give that to you. Make sure you fill that out and get that back to me before this hearing is over. Make sure you fill in all the blanks and you sign it and you date it where it says to, because I generally don't consider those if they're not thoroughly completed. And then you call back to my assistant, Missy, later in the week to see if one is appointed and who that will be. Do you need Missy's number, or did you take it down earlier from the other hearings?
no, I don't have.
All right. Missy, do you want to give him your number?
620-583-8155.
And then Missy, when is his next court date?
Well, I haven't explained my position.
Sir, we're not going to have a trial today. You're going to need to talk to your attorney before you have a trial. So Missy, when is his trial date?
I wanted to move.
Sir, please do not interrupt. Missy, when is his And we won't set it directly for, do you want to set it directly for trial, or do you want to set it for a status so I can
I
check
don't
in with you after you talk to your attorney?
I don't know what the status means.
Well, let's set it for a status, Miss Ear Control.
November 22nd at 10.
You, sir, will need to be back here by Zoom November 22nd at 10 a.m. Are you on bond? Let me check.
Why would I need a bond?
Complaint from the cause. There is no bond on the file, and it is an unclassified misdemeanor. So I'm not going to make you file a bond since it's an unclassified misdemeanor. If you fail to come to court, though, most likely a warrant would be issued anyway, and you'd be taken into custody. But as long as you come to court when you're told to, that's not going to be a problem. So you're going to call and get your attorney, or find out if you have an attorney.
I haven't given a chance to
You do not need a bond, and you have your court date.
Number one, I want to move to a motion to dismiss this case because I didn't try for this, and I have the license plates, both license plates. I was not driving anything unlawful or illegal. I'm living in the private. I'm driving in the private, and so I want to move for dismissal with extreme prejudice. And also, I want to make sure that you understand that I want to keep all my constitutional rights. So far, my constitutional rights are being trampled over right now by yourself because you're not giving the chance to speak. I have not given the chance to speak. You're just going over and over. And I'm requesting that you remove this case because this is double jeopardy. I already appeared in court for this thing. I have not been given the opportunity to explain myself. I want to keep my rights, and I haven't been able to keep my rights. You yourself and the lady on the other side signed a oath of office to uphold the Constitution of the United States, and I'm not being given those rights right now, man. I respectfully request that you honor my rights. And I want to move for a complete dismissal because it's double jeopardy, and I already appeared in court.
All right, well, I did give you the opportunity to speak. You were speaking, not I, not Miss Shirley. And so I gave you the chance to say what you want to. If you want to talk to your attorney can help you put together the motions that you've kind of implied, at least, if not outright said you want to pursue. But we will take that up on the date that I gave you to reappear.
I'm sorry, it's breaking up. You said you're gonna take what up to do what?
I can take up any motions that you want to file at a later date. With the next court date, we can revisit any motions or visit any motions you want me to consider.
I appreciate it, thank you. Being dragged down so much, and I have a hard time moving around. As you can see, I'm disabled, and I only come here once a week to the hospital to be treated, and all this court is putting a lot of stress, and I'm not able to heal properly. Why are we dragging it out so much, ma'am?
When did you get this disability? I don't remember you being unable to walk the last time I saw you.
I came in my bike is right here. I have it right here. I don't know if you can see it. But I normally use a walker in a wheelchair, but I'm using the other one because it's easier to carry in the car. It's what's it called? It's knee scooter. I have 2 amputations on my feet. So ambulation is very difficult. I'm having a lot of pain. In fact, I'm under medication right now. I don't have a clear mind. Just so I can be here because it's too painful.
Well, that's why you need to call back here. You don't have to come in person. Call back here or have your wife or helper, whoever that is with you, call for you, and Missy can tell you if you qualify for an attorney and who that attorney will be and how you can get a hold of that attorney before your next court hearing. We did give you the date of that court hearing. You will need to be back here for that, but you can do that by Zoom. You don't have to even leave your home to do that as long as you've got a clear signal that allows us to communicate. So I mean, you're always welcome to come down there to the courthouse like you're doing now, but you don't have to as long as you can communicate by Zoom. And remind me, what town do you live in, sir? Are you from Kansas?
Yes, I'm in Howard, but even last night, when I got the letter from the sheriff, they brought it to me at 5 o'clock last night. I didn't even know.
All right, well.
So it wasn't improperly served. I got it like literally last night. I'm trying to get people to come in and I don't have the time. I don't have the ability to move that fast. And so
You were just complaining a moment ago that this case wasn't moving fast enough, that we were dragging it out. So there you go. Move it too fast, you say.
Yes, but it's dragging on because it should be dismissed.
Hello, sir.
How you doing?
I'm good, thank you. What's your name, sir?
If I can help you. I'm Williams L.
Yes, Your Honor, but the defendant is identified in the docket as Michael Williams. Is that correct, sir?
Yes, that's the name they're calling me, but I am Williams L.
I understand.
Michael Williams, okay.
No, I'm not Michael Williams, Your Honor.
Okay.
I am Williams L.
Okay, so here's the thing, Williams L. I have to call you what's on the documents that I have present for me in court today. We can either handle it that way, or you don't have to handle it, and then it just will be like you didn't show up to court today.
No, so Your Honor, I'm just letting you know who I am.
Okay.
I am Williams L. I am not Michael Williams. They kept calling me Michael Williams. I told them who I was. I am a sovereign, Moorish American. I'm not United States citizen, Negro, Black, or color, Your Honor.
Okay, so let me tell you, Mr. Williams, this is the last time I'm gonna say it. This is all I have for you. If you don't want to handle it under that name today, then I have to act as if you aren't present. And so that's fine, but I
You say what? Hold on. Can you repeat that? Can you repeat that, Your Honor?
If we can't handle those matters and those tickets that's on that case under that name, then that's fine. But it's going to be as if you didn't appear for court today because I have.
Ma'am, I'm here today, ma'am.
Right. So I'm just saying when
Williams L is here today. I'm just letting you know who I am, ma'am. Yes, I do. Okay. I am Williams L.
So that's fine. When I call it on the record, I'm going to have to call it on the record as the name on the ticket, just so you know, okay?
Okay, and I'm going to let you know that I'm Williams L. Okay, I'm cool with that, and I'm letting you know who I am. I'm a Moorish American.
Okay. Did you want to offer? Okay. Did you want to offer for it or no? Are you going to try and I need to kind of know where you're going. Are you going to want a trial? Are you going to try and want to?
No, I do not agree. I do not agree to none of this. I'm sovereign.
Okay, so if you're not going to participate, we're just going to act like you're not here today, and I'm going to go ahead
I am here today, ma'am. You seeing me right here? That's on record.
Listen, just because you show up doesn't mean that you're here. You have to participate, okay?
Ma'am, I'm a sovereign. I'm letting you know who I am. I'm participating. I do not agree.
Mr. Williams, that's fine, but if you don't participate, saying you're a sovereign doesn't help me.
I'm just letting you know who I am. That's violating a constitutional right, ma'am.
So do you want an offer or not? That's my question.
Do I want a what?
An offer to the tickets or not?
Do I want to? I can't understand. You said, do I want to offer?
Do you want an offer? Do you want to try and resolve this today as far as?
Yes, I do want to resolve it. I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
Oh, no, that's not going to happen. So you can, I'm not going
to. I'm speaking for myself. I have no attorney, so I'm speaking for myself. I asked for this case to be dismissed. Violated my constitutional right.
How do you have constitutional rights if you're not a citizen?
I'm not a United States citizen.
So how are you entitled to constitutional rights of citizens?
You got to uphold to the sovereign, sir. You can't. I'm not United States citizen. I'm not Negro, Black, or color. You're not under I'm not under your jurisdiction.
I understand, but my question to you is, if you want to rely on your constitutional rights, how do you have constitutional rights if you're denying your citizenship?
Because I'm an American. I'm a national.
I get it,
I'm a Moorish American. I'm not United States citizen corporate. I'm a Moorish American. I'm an American national.
Okay, but you're still present in this jurisdiction, right?
I just asked for this case to be dismissed off lack of jurisdiction. That's it. I don't want no attorney. I can speak for myself. I'm not a minority. What am I doing here?
He can represent himself. Don't worry about it. You put
I can
yourself on
speak
hold.
for myself.
All right.
I'm speaking
Now
for
calling the
myself.
matters
Y'all
of the
violating my
people.
rights. That's a
Now
sovereign.
calling the matters of the people versus Michael Williams. This is ticket number SP 1212334. Count 1, use loudspeaker without permission or unreasonable noise. Count 2, drove while license suspended. Count 3, no insurance misdemeanor. Sir, please state your name for the record.
I am Williams L.
All right. All right. Sir,
I don't have a name. I have a title.
This is the date and time set for an arraignment on a bench warrant. Do you want to participate in these proceedings?
Yes, I'm here on special appearance. I'm just letting you know who I am.
All right. So how would you like to move forward with this matter, sir?
I asked for this case to be dismissed off lack of jurisdiction, Your Honor.
All right. That motion has been denied. How would you like to move forward on these matters?
I just told you what I would like it, so I don't know. I'm just here on special
It's been
appearance.
denied. So you can either participate today.
I am participating. I'm here.
No.
I'm speaking for myself. I have no attorney, so I'm just letting you know. It's denied, so we can keep going on with proceedings. I am Williams L. I'm not a United States citizen. I'm not Negro, Black, or color. I'm not Christian.
All right. All right, Mr. Williams, it appears to the court as I'm making a record that he does not want to participate in these proceedings.
I told you I wanted to participate. I'm just letting you know who I am. I told you for the record.
All right. He would like to not participate in these proceedings. He has told me that he is the person known as Williams L. and not the person on these tickets. So he is not appearing on behalf of this person. This person has not made themselves available to the court today as an arraignment on the bench warrant. So these matters will stay in warrant status. Thank you so much. That concludes this hearing. Have a good day, Mr. L. Williams.
Williams L.
Williams L. I'm gonna call the case as is.
Okay.
And then I'll refer to you as Williams L. if you would like, okay? Now calling the matters of the people versus Michael Williams, also known as Williams L. This is ticket number SP 1212334. Count 1, use loudspeaker without permission or unreasonable noise. Count 2, drove while license suspended. And count 3 is no insurance misdemeanor. Sir, can you state your name for the record, please?
Williams L.
Okay. And is there another name that you have?
That's not my name. That's just my title.
Okay. What's your title that you have, sir?
Williams L.
And then is that your name or your title?
My title.
Okay. You don't have a name at all?
No, I'm not Christian.
All right. It's my understanding that you don't want to have an attorney, sir. Is that correct?
Yes, sir.
Now, you know you have the right to have an attorney. These matters are misdemeanor matters, and you have the right to have an attorney on these matters, sir. And it's my understanding, no attorney, okay? So let me advise you of your rights. In these particular matters, the court can, since they are misdemeanors, do either, I think, 90 days on one of these and up to 93 days in jail, or a maximum fine of $500. These are all misdemeanors, so that's the maximum penalty that can be given in any of these matters. You have a right to have a trial, a bench, or a jury trial in any of these matters. A bench trial is a trial before myself as the trier and finder of facts. A jury trial is a trial with 6 members of the city of Detroit who will come in here and hear the same information and make a decision based on that. These are your rights that you have right now. You also have a right to have a pretrial. What that does is that gives you time to think about any offer that may be given to you. At this point in time, there has been an offer extended to you that if you are willing to plead to the no insurance misdemeanor, it will be reduced to an improper place. I set the fine that goes with that. You have a right to, you can also move for a motion. If you know how to file those, you can file a motion as well. So what's your pleasure at this time, sir?
I know I'm under common law. I'm not under statutes or codes or regulations.
So when you drive on any city street in the city of Detroit, any road in the state of Michigan, you now avail yourselves, whether you wanted to or not, to the laws and states and regulations that are governing us. So you may not have wanted to, but you did. So these are your options at this point in time. If you choose not to, if you were traveling, if you were driving, it's all the same.
I wasn't driving, I was never.
So If you were just in the vehicle as a passenger?
I was parked. And they was harassing. Was
You sure
never
you
driving.
don't want an attorney?
I'm under common law. I can speak for myself. I'm not a minority. I'm a sovereign.
So what option would you like today? Of those that I gave you, sir? You can have.
Ma'am, I'm a sovereign. I can't, I do not consent. I can't. I can't
So here's
consent.
what's gonna happen. So I want to make sure you have all the options. You can't consent to anything. So that means that you don't want to participate in the process. So it's just gonna go back into warrant status. Because you have to pick one of the options, yes.
Ma'am, I'm a sovereign.
And you were in the city of Detroit on a street in a vehicle. And I understand what you just said. That's why I said,
right.
did you want counsel?
I'm not a United States citizen. Nobody have improved jurisdiction. I'm under common law. Statutes don't apply to me. I'm under common law. Supreme Court case, Supreme Court case, Self versus Ray. Statutes don't apply to me. I'm on common law. And if there was a crime committed, can you please show me the injured party? Or I ask for this case to be dismissed off like a jurisdiction.
I deny the motion for the case to be dismissed, so you have these options, or else it's just gonna remain.
And I'm under duress because you forcing me saying you're gonna put a warrant out for my arrest.
It's already out there.
But that's violating my 13th Amendment. You can't enslave me unless a crime is being committed.
So you can't.
You can't violate my constitutional
Let me
rights.
finish talking. You can't claim you're sovereign and then claim rights under the Constitution. That's not how it works. No, that is not how it works.
I'm not a United States citizen. I have a nationality.
Okay, so that means that
you have to go by
either the laws all apply or none of them apply.
The laws do apply. What do you have a liability? Do you have a bond? Did you swear an oath to the Constitution? I would like to see that.
Yes, I was about to say I did do that, but I don't have to show you any of that because I wasn't the arresting party. I'm just here to make sure.
Do you have a liability? Do you have a bond?
Listen, I'm not going to argue with you, Mr.
I'm not arguing. I'm under law.
Mr. Williams L. Those are your options. If you don't want any of those options, it's going to remain in warrant status.
You're forcing me. You can't do that. Okay. You can't do that, man. You can't go against Constitution.
Okay, Mr.
You took an oath.
Williams L.
You swore an oath to follow the Constitution.
I did.
That's why I need your liability bond. Do you have a liability bond?
No.
You don't have a liability bond?
No.
Wow, man. Somebody's going to get in trouble. I'm not trying to get nobody in trouble.
Yep. Okay.
Okay.
Mr. Williams L. I was about to say, if you don't want any of those options, then your only other option is that I have to leave it in warrant status.
I do not consent. I'm here. What warrant? That I didn't show up?
That you didn't want to choose one of these things.
I don't have to. You can't force me to do that, all right?
You're right.
You can't force me. You can't put a warrant out. I would like to talk to somebody, a chief judge. You're violating my constitutional rights. You can
go to the fifth floor and make a complaint.
That's because you're violating my constitutional rights.
All right.
And I'm going to ask the sheriff for your liability bond.
Okay.
Hey, I don't want to do that.
Okay, you can ask him. Go ahead and ask the sheriff for my liability bond. It's fine.
Took an oath to swear to the Constitution. Took an oath. I'm under common law. I'm not under statutes or regulations.
Okay. Thank you, Mr. Did you get all that, Miss Sandy? Okay, fantastic. All right, that concludes this hearing. Thank you so much.
I'm not Negro, black, or color for the record.
Okay. He said he's not black or color for the record either, okay?
No, I'm Moorish American. I'm a Moorish.
Moorish American, and he's a sovereign.
I have a nationality.
I'm not threatening you. Say one more word, and that's 30 days. 30 days.